Good morning. Today I am called to be a witness in an ongoing civil trial. This will be the first time I'm attending open court to testify as a witness on oath. I have been, I suppose, a supporting witness. We call it a deponent in our jurisdiction, Malaysia, where I had to affirm affidavits in support of applications for my client's cases. And I have been, the investigation agencies had recorded my statements for other purposes. Lawyers sometimes are called upon by investigating agencies to assist in investigations where, we had prepared documents, or we might be acquainted with somebody who might be connected with the case. But this time it is a civil matter, and it is, it's the first time that I'm actually called to go to open court to testify before a judge. It is an interesting feeling now because, all this time I've had experience of preparing witnesses, drafting their witness statements. In criminal cases, we call them written statements, examining them, cross-examining them, reminding them of things, making sure that they don't forget what they need to say, all the while being careful not to breach our code of ethics, because we're not supposed to coach witnesses, and also reminding them of their rights as witnesses, and reminding them just to tell the truth. That's my role as counsel that I do every day. But now I'm the witness. It is indeed a different feeling. But at least I just need to focus on what I need to say. I don't need to focus on the case as a whole. Though, admittedly, being a lawyer, I need to. I need to make sure that, or rather, I'm concerned that I deliver my testimony clearly, fairly, and properly. I'm like wondering, how's the plaintiff's counsel going to cross-examine me? How's the defendant's counsel going to cross-examine me? Are there going to be questions from the court? So I'll just, I'll just attend and just fulfill my duty as a tetamu mahkamah, as I was taught. I was taught that a witness who has been subpoenaed or otherwise invited to the court is tetamu mahkamah. They are a guest of the court. So in this particular instance, I was not subpoenaed to the court. It's a civil case. I was informed by one of the parties to attend and testify, and I agreed to do so. In our country, there are several procedures to ensure that witnesses attend court. The straightforward manner is by subpoena. There's subpoena and subpoena ducis tecum. Subpoena is for the witness to attend court and testify. Subpoena ducis tecum is for the witness to attend for producing a document in their custody or power. And in practice, they are indistinguishable. You don't ask the court for a subpoena ducis tecum. I mean, you ask for a summons to be issued to a person acquainted with the case to attend. However, in civil practice, by and large, you want your witnesses to cooperate with you. They are generally, though not always, they are friendly witnesses. You don't want to call witnesses who you think will be hostile or testify against your case. So you just write to them and you ask them to come to court. You don't need to subpoena them unless they are unfriendly witnesses. In criminal cases, they are subpoenaed even if they are friendly to the complainant or to the state. Even if they are police witnesses, they are subpoenaed. Sometimes in criminal cases, the investigating officer, who is primarily responsible to apply to the court for issuance of the subpoena, sometimes they forget to do that, or they don't do that, or sometimes they only do that if instructed by the prosecutor each and every time, umpama pahat dan penukul. Of course, it doesn't apply to all investigating officers in all agencies, just a lot that I've come across. Not all, of course. Sometimes they omit to do so. So what they do is they just call up the witnesses. Or for police witnesses, they issue what is called a semboyan. I'm not sure what it's called in English, and I'm not really sure what a semboyan is. I've seen them, but I don't know what it is. It's like a fax. I don't know if it's still used in fax nowadays. Is it still used in fax? But 10 years ago, I've seen them when I was a prosecutor, that they were faxed out. Faxed out to the respective police districts or police contingent, notifying the superior of this police witness that they have a case in court, and requesting that this officer be released for court duty. So they need permission from their superiors because they don't have freedom of movement. They professionally they need permission to leave their district or within their immediate area. And often, courts, to attend cases, it might be outside of their police district. What I've also observed, and I've heard that there is an agency in this country that they don't need to issue subpoenas because the witnesses are white-collar witnesses in general, and they're scared to death of this agency. And this agency, all they need to do is just call them up. This agency is not the police, and it's not the Securities Commission, it's not the tax agency, it's not the customs agency. That leaves several agencies out there, right? I'm not naming names. So what I've seen is they don't even subpoena the witnesses. They can subpoena, but I've seen that they don't. The witnesses just come because the IO just calls them and tells them to come. Sometimes very short notice is given. And why do they comply? Why do these witnesses don't fight for their rights? Because they are scared of this agency. This agency can freeze account nearly at will. They can arrest people nearly at will. And they have many powers and immunities under law to do as they see fit. Of course, in the name of public interest and justice. But who is to say? I'm just stating as a fact that they can cause witnesses to materialize even without subpoena. What is the relevant? What's the importance of subpoena? Is because you need to go to the court. You give the court a list of your witnesses, and the court will make sure that the name and the IC and the address is all there. If the particulars are incomplete or perhaps a little bit imperfect, the court might reject your application for subpoena. That has been my experience. However, when I was a prosecutor, I know that subpoenas were issued even though they were imperfect. So I guess it depends on the respective registry of the courts. So back to my scenario, I'm not off the hook yet. I'm awaiting my turn, which is going to be in about an hour or 2 hours. I'm not the first witness, and I'll be shown documents, and I'll have to testify and document on what I know about it. I hope I'll be able to share more of my experience once I come out of it today. Wish me well.